Hi Cyberclass, it's Professor Opterbeck, and welcome to our week on cybersecurity and private law focused on torts. You saw from the beginning of our class this semester a lot of emphasis on public law, that is, on governance type issues and on criminal law. And I wanted to add into the course this year a deeper discussion of how private law concepts, particularly contracts and torts, influence cybersecurity and relate to cybersecurity law, particularly in the United States. So last week we looked at the question of contracts and private ordering in cyberspace and how that affects cybersecurity. And this week we're going to look at torts. And as I said in the introduction to the week in my email introducing the week, this is an area I've done a lot of work on and I'm really interested in, and I'm continuing to do a lot of work on. And I taught torts for a few years when I first started teaching, so I have kind of a background in torts in that sense. And when I was in practice, I did a lot of product liability cases, especially early in my career, kind of big product liability cases and big consumer fraud cases that actually were class actions. So I have quite a bit of experience and interest in the way in which the tort system potentially functions as a regulatory vehicle through private law. And we can kind of look at this through talking about the concept of externalities, which we've talked about a bit before in our class, but just kind of as a little bit of reminder. Here's a kind of a classic example of the way externality theory works. So let's say we have this factory here, and the factory is producing widgets, whatever the good is, we'll call it a widget, and the consumer here is buying the widget, right? And so the consumer is paying some price for the widget. Now, under kind of normal, market kind of conditions, we could have our kind of classic, demand curve, and we can say there's a certain price, right, and there's a certain quantity of the good. And so let's say our price is here, our quantity is here. If we raise the price, right, we end up with a lower quantity and higher price and so on. And so how does in a market setting, how does a price get set? Well, ultimately, there's also going to be a cost curve. This is the producer's cost, right? And classic economic theory tells us that if there's competition, the price is going to eventually congeal on the marginal cost to the producer. So and the marginal cost is the cost of each additional unit that the producer produces. And so in this way, the producer can stay in business, and the consumer is getting the product. Now, of course, producers want to make something above marginal cost, and there's other various ways in which a producer can try and get an advantage in the market and do that. But this is what our market theory tells us. So the cost of the producer, right, is going to be closely tied to the price of the good, and we presume that the consumer, because we have a demand curve, right, and that demand curve reflects the value that the consumer is putting on the good, and that's going to all be reflected in this transaction. If the market's working perfectly, and no market ever works perfectly, but if the market is working perfectly, we have an equilibrium that is efficient for everybody. The producer stays in business, the consumer gets the good at a cost that is valuable to the consumer, and the right, a sufficient quantity of the good is being produced for the people who want it. Okay, but what if the factory producing the good is polluting the atmosphere? All right, and that pollution is affecting a third party. Let's say it's wafting into a neighborhood near the factory, and this third party is not a party to the transaction. This party is not buying the widgets. So this imposes a cost on this third party. And it may be a cost that we could actually, actuarially calculate. It may affect the health of the people living in the home. It may affect the value of the home, right? All these kinds of things can be the cost that's being imposed by the pollution. This cost, external to the transaction itself, is what we call an externality. And it's kind of a very, sort of simple way of illustrating an externality. In this in particular is a negative externality. You can have, this could throw off a benefit onto a third party, which would be a positive externality, but this is a negative externality. And so now we'd say this picture of social efficiency of the market is oversimplified because we're not accounting for this external cost. And regulatory externality theory says we want this cost to also be reflected in the original transaction. We call this internalizing. Internalize. We want to have the externality be internalized. And now, what will that mean? So if we just kind of put this cost in the original transaction, well, it might be this person is still being affected by the smoke. So, there's a bunch of different ways we can do this. One way is we can just come up with a regulatory rule, and it says if you have this kind of smoke at a certain parts per million or whatever, you pay a fine. All right. We could have a tax. And the tax is actually more likely to be on the good itself. So if the good is produced using this kind of smoke, right, the good is taxed and the consumer pays the tax. And another way we can do it is through torts. So we can say this party has a claim in negligence or some other tort cause of action to recover from this party these damages. And so that serves the purpose of remedying the externality that was imposed on this party. We have a remedy function, right? It also ideally serves a purpose like these other regulatory rules of deterrence, because the factory looking at how it's going to build out producing the widgets is going to have to take that possible future cost into account. And then it may invest in technology that cuts down on the smoke, or it might find an alternative production process, or it might move the factory somewhere else, right? And the same thing applies with the possibility of tort liability. The other thing that tort does is it drives insurance. So, a regulatory rule or a tax is relatively certain. The rule says what it is. Obviously there's can be play in the joints of whether you're actually violating a rule or not, but the rule says what it is. If you violate the rule, you have to pay. The tax is what it is. You're going to have to pay the tax every year. But tort liability is uncertain. We don't know exactly what the scope of a duty of care might be until there are a sufficient number of cases defining that. We don't know exactly how a given court and jury might hear a certain case. That uncertainty means that enterprises like our factory are going to buy insurance to protect against kind of large-scale tort judgments. That insurance spreads the risk of loss really among everybody. By the way, all the costs, additional costs that the factory might incur are going to end up going into the price of the widget. And it also helps drive compliance because insurance requires underwriting. The insurance underwriters before they approve the policy, are going to want to know what the factory does and might put requirements or recommendations about how the factory functions. So regulatory rules, taxes, all ways of internalizing externalities, but also tort law. And so to me, one of the really interesting questions in cybersecurity compliance is whether tort law has this kind of function. Now, we do have some regulatory rules with cybersecurity, and we see in the U.S. they're a bit piecemeal. So we do have that. And by the way, none of these things are mutually exclusive. We don't really have kind of tax for cybersecurity in the way that we have alcohol taxes or petroleum taxes or tobacco taxes, right? All these are ways of addressing externalities. So we don't really have that. I don't think I've even seen proposals I may have seen one or two proposals on the taxation side, but mostly the legal proposals are rules and the possibility of torts. And in the American context in particular, the tort possibility is kind of tantalizing and interesting because of the function of class actions. In the case that we're sort of illustrating here on this slide, presumably you have some significant harms to the individual. I mean, maybe the person gets cancer, and so there's significant medical bills and pain and suffering damages, or maybe the property values in a whole area are affected, so there's significant damages in an individual case or a discrete set of cases. But a problem you have in some tort claims and in cybersecurity is that any harm to an individual is likely to be fairly small. So I mean, if your credit card is hacked and you suffer $50 of out-of-pocket losses, you're not likely to file a lawsuit for that because the filing fee for the lawsuit is going to be more. So the ability of class actions to aggregate claims, and then further, the way class action litigation has developed in the United States over the past 50 years or so is that most class actions lead to settlements, and those settlements have an internal structure to them in the way that individual claims that are relatively small can be more expeditiously and cheaply presented, maybe through a claims panel or maybe through a very simple process, and individuals get some remedy. So in the toxic tort area, which is really what I'm illustrating here, or in the environmental area, there's a lot of literature about the extent to which that class action mechanism functions as a bigger kind of regulatory and even insurance system. And my question is, how might that work? What might that look like in cybersecurity? So the first paper of mine that I asked you to look at is my paper on the economic loss doctrine. And I got really interested in this one because I'm reading these, data breach litigation cases, class actions that are coming through the federal courts over the past decade or so. And you have a lot of cases that are getting dismissed on standing grounds because of the way the credit system works. And I'll talk about that in a moment. But then you also have the merits of some claims getting dismissed on the economic loss doctrine. And I wanted to really inquire about whether that made sense and what the dynamics are. And almost all of the cases almost all the class action cases, I should say, were consumer breach cases. Now we had Equifax, which is kind of its own animal, but because it's credit reports. But a lot of the cases have to do with the theft of payment card information, a credit card or debit card, and the actuality or the possibility that the data thief, or actually more realistically, someone who buys the stolen data on the dark web, will use the credit card number to make fraudulent transactions. And so to understand, how all this works, you really have to understand the way credit card payment networks work. And it's a really, really interesting kind of economic and business setup. So we all, if you certainly have credit cards or debit cards, probably there's a card brand. So Visa, MasterCard are the two largest brands. American Express is next. And then you have Discover. And then there's a few other kind of minor brands, but those are really the major brands. So the card brands have contractual relationships with banks. The issuer bank is the bank that actually issues, the individual consumer issues you or me our credit card or our debit card. The acquirer bank is a bank that has agreements with merchants to process credit card transactions. All right, so Visa, MasterCard, Discover, Amex have agreements with the banks. The agreements allow the banks to use the brand. There's brand, right? They also allow the banks to use network services, and this is really significant. These major brands have really massive, basically intranets in a sense, but sort of portions of the internet or their own networks for processing the billions of credit card transactions that are regularly happening. And it's not just the brand, but it's the access to those services for processing all of these transactions. That is what the banks are paying for in membership dues and transaction fees. The issuer bank has contracts, right? So let's note that these are contracts, right? The issuer bank has contracts with you and I, the card customer. And the issuer bank is looking at our credit application and is going to extend to us a certain amount of credit for a certain interest rate and perhaps also for certain fees that we pay on the use of the card. In the case of a debit card, it's not credit, but it's automated access to the money that's in our accounts, and there are banking fees that go along with that. The acquirer banks, so a contract there. The acquirer banks have contracts with the merchants. What the acquirer banks do is when a transaction happens, so the customer, this is a contract as well, right? The customer's buying something from the merchant. You go online, you're buying a book from Amazon, there's a contractual relationship established, right? And the merchant is sending the goods or services to the customer. The merchant is that transaction gets transmitted to the acquirer bank. The acquirer bank is reimbursing the merchant for that transaction. So the money is actually not coming out of your account. It's coming out of the acquirer bank's account, reimbursing the merchant. And in the most typical way this works, the merchant is paying a discount. So in other words, if the book you bought is selling for $10, the acquirer bank is funding the merchant, $9.85 or something like that, and is keeping the other $15 as their fee. All right, so you have that happen. Now the acquirer bank has laid out money. The acquirer bank then has contractual relationships with the issuing bank. And the issuing bank is going to reimburse the acquirer bank for what the acquirer bank has outlaid to the merchant. And so that payment is going to be made, and the issuer bank is going to charge a fee to the acquirer bank for that reimbursement. So you can see there is a network of different commercial contracts in which each of the players at different points along this web are getting some services and are charging certain fees. And that's the way the credit card payment network functions. Now, one of the key aspects for our purposes of discussing the economic loss doctrine and data breaches is that there is a guarantee between the issuer bank and the card customer as part of this contract that if there is fraud, the issuer bank will reimburse the card customer for any fraudulent charges on the account. And I'm guessing probably most of you have had a fraudulent charge on a credit card or a debit card. I have several times. Most people have, because this is a really kind of frequent thing. The issuer banks actually have really good algorithmic ways of spotting improper activity, and so they often spot it, or you might spot it on your own account, and pretty easily in almost all cases you will get reimbursed. Now, and there is a federal law that requires this reimbursement, but carves out, I think it's $50 that they don't have to reimburse, but all of the card brand agreements with the issuer banks require the issuer banks to have contracts with the customers that provide full reimbursement. All of the card brands do this. So by the way, if you see an ad that sort of talks about the fraud protection of one card over another, maybe their algorithms are better at detecting fraud, but the reimbursement policy is the same everywhere. So what happens if it is determined that your card was compromised because the merchant was breached? Right now we have the issuer bank is out of pocket because they have had to reimburse you, the customer. Does the issuer bank have a claim against the merchant and/or a claim against the acquirer bank that has a contract with the merchant to recover the amount it reimbursed? And if so, what would be the basis for that claim? And the short answer is yes, there is a mechanism within these contracts. Part of the card brand contractual arrangement includes security standards and includes a dispute resolution mechanism that allows for this kind of loss from fraud from the issuer bank to be reallocated. And so within that process, if the issuer bank says the merchant didn't comply with the security standards, and the kind of main security standard is called PCI DSS within these agreements, and that is just a kind of set of protocols for what merchants and banks are supposed to do to secure their systems and consumer credit information. And so if that's demonstrated, right, these networks adjust within themselves. Now, there have been some claims, some tort and breach of contract claims filed in federal courts and other courts by banks or other players within the payment network chain. And for the most part, from what I have seen, courts have dismissed those cases because the internal contractual relationship already adjusts for all this. But there have been a couple of cases filed. So this is a way of private ordering, right, of a web of contracts, potentially addressing what otherwise could potentially be a claim sounding in negligence, because the possible claim would be that, well, the merchant or the acquirer bank failed to use reasonable care in securing its data and securing its networks, causing a loss, right, to the issuer bank who had to reimburse the customer. Instead, the contracts say, here are the conditions, under which there can be some recovery within this network. So that complicates the tort claim, and it particularly complicates the tort claim under the economic loss doctrine, because the economic loss doctrine is historically precisely set up to adjust the question of, is a claim really one sounding in contract, or is a claim really one sounding in tort? Now, I just want to throw in one other, the schematic I gave you here is simplified and more than a bit oversimplified, and it complicates things because in most circumstances, or in many circumstances, there is another player beyond the four that we mentioned, the five that we mentioned, the two banks, the merchant, the customer, and the card brand, and that is a payment processor. So payment processors are third-party entities who are not banks, who provide services to the banks in helping them process payments, right? So they are outsiders to that web of contracts. Now, they have their own contracts with the banks and merchants that they're doing business with, but they're outsiders to the network contracts, and that does complicate things. And there have been a case or two in which there are separate breach of contract claims involving these third-party processors, and it further potentially complicates the question of the economic loss doctrine, because what contractual relationship is really addressing the kind of risk that the tort system might otherwise be addressing. So the economic loss doctrine is one of those old rules that you probably came across briefly in torts class in the first year and sort of forgot about. But it's really interesting, and it provides some functions. So And one of the key functions that it supplies is what is a claim in contract versus what is a claim in tort. And the kind of traditional rule is to say that if it's an economic loss only, not a personal injury or a harm to property, then the appropriate form of remedy, if any, would sound in contract and not in tort. Why would this even matter? Well, the remedies are different. In contracts, you don't get pain and suffering damages. In contracts, kind of the expectancy damages can be more circumscribed than they are in torts. So it helps establish that boundary. It also potentially serves as a surrogate for proximate cause. Remember back to first year torts, when you kind of labored through the Paulsgraf case and the meaning of proximate cause. And proximate cause, we kind of say, all right, this is our chain of causation. Here's all our links in the chain. We might have but-for cause, but at some point, we're just going to say the links get too attenuated, and we're not going to impose tort liability. We might do that based on some kind of concept of foreseeability, or we might just kind of acknowledge it's really kind of a policy judgment, right? What is really recoverable? At some point, we have to stop that chain and make it not tort. And the economic loss doctrine is another way of doing that. You can recover for personal injuries. You can recover for property damage. Think of, if you studied in torts, the case involving a frozen river, and there are barges on the river, and there's a bridge, and a barge breaks loose, and the ice hits the bridge, and the bridge collapses, and the water kind of floods the surrounding area, and there's a factory that suffers property damage, but then the factory also loses future orders because it's shut for a period of time, and the case kind of sets this idea of proximate cause at the property damage and not sort of the future orders, because and that is a foreseeability analysis, but it could also be an economic loss doctrine, because you're saying those future orders, they're just money, right? They're not the property damage itself. Factory, you ought to, in your contracts with those who may be submitting orders and to those whom you may be delivering, kind of adjust that. All right, and then externality theory. We come back to our idea of externalities. So we said tort system supplies the market in externalities. In other words, torts is a way of forcing externalities to be internalized. But if externalities are slight, or if a contract or a web of contracts internalizes them themselves, then we don't really need the tort system. And so if we go back to our web of agreements here, the question is, well, this lack of care, right, even though the immediate contract the merchant has is as to the credit system is between the acquirer or bank, imposes a cost on the card customer. So does this web of contracts adequately address that, given that, the card customer gets its money back from the issuer bank gets it back from these other parties based on the PCI DSS standard. So in my economic loss doctrine paper, I take a look at the externalities of consumer credit card data breaches. And I use the term network externalities because, I am kind of trying to suggest that because credit transactions involve this web of relationships and really enmesh the whole consumer economy, that the externalities actually scale, right, larger. And one question is whether the zero liability policy for a consumer in recovering from the issuing bank fraudulent charges encourages lax consumer discipline. Now, there are kind of caveats on things that are kind of your own fault, but that's sort of rarely explored. So concerning asymmetric information, I had found an interesting paper by Stacy Schreft, who was at the Federal Reserve Bank, and her position was that the parties best able to invest in security, in particular the merchants, are going to have different information than the acquiring bank, and are going to have very different information than the issuing bank or the consumer. And they're going to have, therefore, less of an incentive to invest in security, because they know that the acquiring bank doesn't really know whether they're truly compliant or not, and the customer has no idea whether they're truly compliant or not, nor does the acquiring bank. And her view is that, the security and integrity of the overall payment system, because it's so fundamental to our economy, is a kind of public good. In other words, it's something that the market is not going to necessarily efficiently provide. I think I was more taken with Schreft's view when I wrote this paper than I am now, because I would question a bit kind of the role of compliance and basically underwriting practices within qualifying to be part of the credit brand network system, and whether that in fact does more work than she thinks, but it's an interesting point. And then Hal Varian, another economist who's does a lot in consumer protection areas, talks about the problem of weakest link security, and his point is, which I think is an important one, cybersecurity is a weakest link kind of chain. The overall state of security is only as strong as the weakest link. And so if there are sort of any imbalance in incentives for example, for a merchant to kind of keep its security practices strong, there's a good chance of a breach, and that imposes costs. That sort of weakest link factor poses costs on everybody else. And then the third piece that I thought was important for this question of network externalities was this issue of third-party payment processors, which it injects this other party who's not directly in the credit card networks and another set of contractual protections or not. Actually, I think the third-party payment processors really extends the problem of asymmetric information, because now you've got this other party who's only dealing with one other player potentially in the chain. So in the economic loss paper, I briefly talk about a few possible solutions from other scholars to this problem of externalities in cybersecurity. My friend and colleague Derek Bambauer at Arizona, who's a great cybersecurity law scholar, talks about not really regulating, but incentivizing more investment in infrastructure, which is a good idea. Nathan Sales talks about a similar kind of idea of public investment, but not so much in the infrastructure's resilience, which is really what Bambauer talks about, but in prevention. And in this paper, I talk about a role for negligence law. So here I'm a little more sanguine, thinking negligence law might have a role to play. We do have kind of the role of class actions that aggregate small claims, and there are a number of policy and doctrinal reasons why the economic loss doctrine shouldn't necessarily bar these kinds of claims, because there are these externalities that the contract network isn't necessarily capturing. I still stand by my conclusions in the economic loss doctrine paper, particularly as applied to cases in which consumers suffer a real out-of-pocket loss. But I've grown a little less sanguine about the role of tort claims in cybersecurity as the next couple of papers that I asked you to read of mine. And in particular, my paper on class action, my empirical paper on class action settlements, which isn't published yet, but I'm updating this year, and I'm hoping maybe to publish next year. Really kind of refocused me on what class actions actually do and what these claims, what these cases are actually doing. So traditionally, as we've mentioned already, class actions aggregate small claims that would be too small to proceed individually. And in doing that, they provide a remedy, and they also, they deter breaches of duty of care, or in economic language, they force some degree of internalization of externalities and some degree of insurance, right? So here we have our internalized externalities, right? The problem, though, is that since most of these cases settle, we really have to look at the structure of class action settlements to determine what the cases are actually doing. Now, a class action settlement is, as you might know from civil procedure, is a unique animal. Federal Rule of Civil Procedure 23, which is the class action rule, allows for class settlements, but they have to go through a process where ordinarily they get preliminary approval from the court, and then there's a period of time in which the initial relief under the settlement gets administered, and then the parties have to come back to the court and get final approval of the settlement. And only then is it clear that all of the class members are bound to the settlement, and there's res judicata effect to what is happening. And there's some interesting scholarship on the role of class action settlements and whether they get gamed in such a way that they really don't end up providing the functions that class actions are supposed to provide. So Nagarita talks about the fact that a settlement itself is a kind of business transaction, that it really isn't so much about the claims of the class members as it is about how is the entity, usually a corporate entity that is facing this class action, going to close out this potential cost and get res judicata, and how are the plaintiffs' lawyers who are bringing the case going to get their fee. And I definitely, in practice, when I worked on class action cases, I worked on one big consumer fraud case where I was on the settlement team on the defense side and really saw in the negotiations kind of this dynamic in action. Now, I mean, one response to this is that, well, every litigation, there's always a side, because you have lawyers involved who need to get paid, and you have companies that want to close out a risk. And at the end of the day, even our tort system, all it can do is transfer money, right, one place or the other. So you reduce anything to money, you can reduce it to a number, and you can find some way to resolve it. So in one sense, that's true. It's just a function of the way that we use money as a proxy in these cases. But it does raise questions about how these deals are negotiated. And then Howie Erickson talks about red flags of settlements, which, if you look at settlement agreements, is the value to the class that's represented to the court exaggerated? Is there injunctive relief or coupons or other things like that don't really provide a lot to the class member? Do the class members have to submit a claim that is difficult to get through? Are there funds that are set aside that represent the value of the settlement that, in the event they are unclaimed during the claims process of administering the settlement, revert to the defendant? So these are some things you see, and things that I wanted to watch out for in the empirical study I did of data breach class action settlements. The version of the paper I gave you was current as of, I think, the summer of 2020, and obviously you can see for different reasons I got interrupted in the empirical work, although I've been collecting data, and I'm as I said, I'm planning to update it this year. So the basic features of most of these settlements, and there were about I think 40 that I had found that had 38 to 40 that had gone to a final court approval. So there's a fund or a guaranteed amount from which the awards would be provided. You can see, I have in the paper and on this slide kind of the means and medians of the amount. A basic cash award, which would go to class members, but to get the cash award, sometimes every class member would get an automatic minimum payment, but usually the class member had to file a claim, and this is one of Erickson's potential red flags. So what do you need to do to prove your claim? You need to prove that you actually lost time or lost other expenses to the breach. And if you were reimbursed, right, by your issuing bank for a fraudulent credit card charge, you would not usually be able to recover that. And I'll show you in a moment some numbers on how many claims were actually made. An enhanced cash award so there was money set aside for a larger award in the event someone, got sort of sucked into a bigger kind of web of identity theft that took more effort to resolve, which I think is actually relatively unusual. A big piece of all these settlements is for the company to provide credit monitoring and ID theft protection insurance, usually for a year or two. So the company pays the premiums, and if you're part of the class, you get the insurance. Some kind of commitment to enhanced data security measures in many of these settlements, although that commitment in most of the settlements was under seal. So it was impossible to know what exactly that meant, and I wonder what enhanced measures mean. Some of these breaches were probably breaches that are going to happen even if reasonable care is used. Remember, the case is settled, so the question of reasonable care was never really tested. Some of these were just obvious blunders, a failure to implement a patch that's 6 months old that allows a bad guy to get in. So, but often the companies claim that this is a big cost and a big value to the class when it's questionable what anybody could be doing other than sort of ordinary good cybersecurity. And then, of course, there's always a fee award. This is how the plaintiffs' counsel make their money. The fee award is, I'll show you one piece of data from the study, but the fee awards in class actions are one of the things that you've got to demonstrate to the court in the final settlement approval is fair and reasonable and adequate, and there are metrics that courts use to judge the fee awards, and one of those metrics relates to the size of the settlement fund and or other benefits provided to the class. So as I mentioned, almost all of these settlements have some kind of claims process where a class member could say that they suffered some out-of-pocket cost and potentially get some relief for that out-of-pocket cost. Now, whenever there's an out-of-pocket remedy or a monetary remedy in a class action settlement, I shouldn't say whenever, but very often, there's a claims process associated with that. And when you go to the fairness hearing, so right, you've got your preliminary approval on some date, usually say 3 to 6 months after, you've got your fairness hearing, at which the court is going to say whether it gives final approval to the settlement. So in between here, you have claims. Now, sometimes the claims period closes as of a date before the fairness hearing. Sometimes the claims period extends beyond the fairness hearing, but one way or the other, the court is judging, how many claims are made and how are those claims being handled. And this is one of this is one of Erickson's pushbacks and one of these kind of structural pushbacks about these kind of settlements is that a relatively low percentage of class members ever submit claims in a process like this. So you can see the numbers here. Equifax is higher. Equifax is an outlier in many ways. It's the biggest data at the time. It was the biggest data breach in history, and it involved credit monitoring, which is different than most of these other cases. So this group of cases here, this is healthcare information. This group of cases is credit information. Ashley Madison is unique because Ashley Madison was a site that people used a dating site for people who wanted to commit adultery. Ashley Madison, a extremely small claim rate because I think very few people wanted to submit a claim and admit that they were part of this site. But these others, these are low. They're not necessarily atypical for class action settlements, and it raises questions about, who's really benefiting or not. And, this one shows the amount that was paid per claim. So again, Ashley Madison, those who did claim, got fairly large rewards because they're arguing that their reputations were really harmed. These other ones, these are pretty small amounts, and they kind of suggest for one reason or another an amount you weren't able to get on the fraud protection policy of your card, or an hour or two of your time that you took the trouble to document in the claims process. Now, there's lots of other tables and other data that I hope is interesting in the paper, but the other one I'll just highlight is the most of all the regressions I ran, the closest fit was the attorney fee award to the settlement fund amount. And why was that a really close fit? Well, it was a close fit because that's one of the big factors that courts look at to approve the settlement. Now, you might say, well, that's good. That all the parties are doing a good job. They're kind of having a reasonable fee amount that reflects the value of the settlement. But it's also very fair to say, from day one, when you're beginning to negotiate settlement in a class action, you're negotiating with those rules in the background, and so you're trying to get to a place where the plaintiff's attorneys are going to get paid, right? And the company can, write down a risk, write down a liability, and be done with it. So it is a negotiation in that sense. The third of my papers that I asked you to look at is my most recent one, which is coming out in the spring. And you can see in this paper I'm growing even a little bit more skeptical about the role of the tort system in cybersecurity. And particularly in this paper, I'm drilling more into the results of cybercrime. I mean, when your PII is taken in a data breach, where does it go? How is it used? What kind of harm, if any, is it actually causing? And I have some themes in the paper that we've talked about in this class quite a bit. Just how sophisticated cybercrime is, how it connects with nation states and organized crime, how ubiquitous it is. And I list a bunch of ways in which PII gets used. And my paper on the economic loss doctrine, my empirical paper on data breach settlements, focus on the kinds of cases that had been brought, which were really mostly, as we said, payment card fraud. And I think one of the interesting things in doing this paper is that the cybercrime ecosystem is in some ways moving away from payment card fraud toward ransomware, because there is so much payment card data out there already on the dark web. The monetary value of it is actually getting smaller. It's not that it doesn't happen, it certainly happens all the time, but it's getting smaller. And then true identity theft, which I think is a lot of the focus of some of the scholars like Dan Solov, who's a great scholar in this space, which is a real problem, but in my judgment, based on the information I saw, is actually kind of a much narrower slice of the problem, and then a bunch of other sort of possibilities. And as I look at the kinds of harms that some of these scholars are suggesting, and when you read my response to them, and if you do read Solov's paper, which I gave you the reference to in the reading for this week, they really want to have broad kind of emotional harms or dignitary type harms. And the question is, number one, empirically, do people really care? If you haven't seen the Have I Been Pwned website, you should take a look and put your email address in there, and you can see how many times your information has been breached. 17 times for my Gmail alone. And yeah, it's concerning, but it is what it is in a lot of ways, right? And then, doctrinally, I think digging into the existing legal doctrine and the reasons for it, the policy reasons for it, it doesn't really seem to me that there is this kind of trend that some other scholars suggest. And I think there are some problems with other kinds of remedies that people look at, which are sort of like medical monitoring kind of damages. So it's a prophylactic remedy. This is this would be a remedy through which you would get that identity theft insurance, and that is, of course, a big feature in those data breach settlements. But if you look at the cases, I'm not really sure that the toxic tort cases are analogous in terms of the kinds of evidence, the kinds of proofs, and the kinds of policy reasons that you would have. And I'm also growing more and more skeptical of identity theft insurance itself and what it actually does. And if you look at some of the exclusions, and one of the big ones is if you are already reimbursed for the loss, the insurance doesn't cover you for that loss. So again, the major category of out-of-pocket loss is going to be payment cards, which you're going to get reimbursed for within the payment card system. So, in that paper, I'm a lot more skeptical. I really like what I did in the economic loss doctrine paper, and I really think that those kind of specifying that and suggesting there is a role for the tort system, the economic loss doctrine shouldn't really be the bar, is correct, because I think that the what I call those network externalities means that the boundary between contract and tort is much fuzzier than the standard economic loss doctrine would suggest. But my work on the class action settlements and on the theories of data breach harm leads me to think that it's probably a much narrower slice of cases in which the tort system can have a real impact, where there is real demonstrable out-of-pocket loss that isn't reimbursed. And all of it you can see at the end of my economic loss, at the end of my paper on harms, leads me to suggest a few other possible reforms, one on the regulatory side, and then some other things with the Social Security number system. And I suppose maybe the next phase of my work on remedies and dealing with externalities and data breaches might focus more on those things. So I hope this gave you some insight into the kind of complexities of the way the tort system may or may not help address data breaches, and I look forward to seeing your comments on the discussion board.